Good afternoon. My name is Ben Olinsky, and I'm the Senior Vice President for Structural Reform and Governance here at the Center for American Progress. I'm delighted to welcome you this afternoon to a great conversation about the now infamous Supreme Court case called Citizens United, and a new CAP analysis identifying a foothold against that corporate political spending that it unleashed. Almost $3 billion of dark money has flowed into our political system in the 14 years since Citizens United was decided. Every presidential year and off-year cycle since 2010 has set a new record for dark money spending, and this one will be no exception. Open Secrets counted $162 million in federal political spending by shell companies and dark money groups in 2023, almost triple the amount spent at this point in the 2020 presidential cycle. Now, it won't be easy to overturn Citizens United. The Supreme Court has become even more hostile to campaign finance regulation since it was decided. And while some of its worst effects can be blunted through legislation, that has been stuck too. The Freedom to Vote Act, for example, would go a long way toward fighting dark money. It would require every entity spending more than $10,000 in an election to disclose all its major donors. It would require better disclaimers on political ads. It would even shine a spotlight on all the money being spent to influence federal judicial nominations. Now, one might think that there would be appetite on both sides of the aisle to pass these reforms. Open Secrets calculates that just over half of the dark money spent in 2023, about 52%, was spent by groups supporting Democrats or attacking Republicans. That's more than half. But in recent years, we have not seen the bipartisan support you would expect that would engender, and the legislation has languished. To be clear, Americans overwhelmingly oppose undisclosed political spending. A 2021 poll by End Citizens United found that 94% of those polled favor making contributions to dark money groups fully transparent. 94%. Former Justice Anthony Kennedy badly missed the mark in Citizens United when he speculated that, and I quote, "The appearance of influence or access will not cause the electorate to lose faith in this democracy." But in the real world, that's exactly what we've seen. As Gallup found last December, a record low 28% of US adults are satisfied with the way America's democracy is working, down almost half from 52% in 1998. With all the forces attacking the integrity of US elections, it's hard to single out any one cause for that decline. But Americans tell researchers that if they had a magic wand that enacted their priorities into law, political and electoral reforms are overwhelmingly where they would wave their wand. Pew Research found that 80% of Democrats and 83% of Republicans say large campaign contributors have too much influence on decisions made by members of Congress. Pew also found that only 11% of Americans favor the unlimited campaign spending that Citizens United has ushered in. 72% of Americans want limits on all of that spending. CAP has been seeking to mitigate the harms of Citizens United ever since it was decided. We have drafted model reform bills. We have thrown our support behind campaign finance reforms, several of which were authored by the members of Congress you'll be hearing from today. We have led the effort to fight Citizens United through the foreign influence corporation laws that are beginning to pass at the state and local levels. And today we are discussing the newest CAP initiative, a strategy that allows U.S. citizen shareholders to hold for-profit corporate boards accountable for misapplying Citizens United and running off with their political rights and their money. To do so, CAP has gathered great champions of campaign finance transparency to discuss where Citizens United has brought us and where we might go next. If you know more about all of this than Commissioner Shana Broussard of the Federal Election Commission, Professor Sarah Haan of the Washington and Lee School of Law, and of course, Congressman Jamie Raskin of Maryland. Their discussion will be moderated by CAP Senior Fellow Tom Moore. But first, we'll hear some pre-recorded remarks from Senator Sheldon Whitehouse, a stalwart leader in the fight against dark money. He is the chief Senate sponsor of the Disclose Act and author of The Scheme, a book detailing how far-right conservatives captured the Supreme Court using dark money. So now I'll throw this over to Senator Whitehouse.
Hello, everyone. It's Senator Sheldon Whitehouse. Thank you to the Center for American Progress for inviting me to speak at the launch of your new report on Citizens United. I appreciate all of the work CAP does to fight for fairness and democracy, including efforts to expose and address the corruption resulting from the Supreme Court's grotesque Citizens United decision. Each year since that decision, elections have become increasingly expensive and less transparent. Dark money groups have poured more than $2.6 billion into federal elections since Citizens United. Billionaire political spending has increased by a factor of 70, from $17 million in the 2008 election to $1.2 billion for 2020. A massive power shift to secretive, creepy billionaires has resulted, and of course, to all their phony front groups. Citizens United shows a court bending over backwards to reach just that result. First, the right-wing majority, supposedly avowed originalists, avoided any originalist discussion of a result that would have astounded the Founding Fathers. It took the dissent to point out that corporations are not equal to people in the Constitution for purposes of political speech, and that the founders would have been horrified at unlimited corporate spending against we, the actual people. At the founding, corporations were few, rare, and regarded with grave suspicion. But we know that for the right-wing justices, originalism is a tool, a doctrine of convenience, employed selectively to achieve their desired result. Second, as I wrote in my recent law review article, Citizens United reached its desired result by making up its facts. That's not the role of an appellate court. The majority didn't just break the rule about where facts should be found. They also ignored robust lower court and congressional factual records. Worse, the facts they then made up are demonstrably false. Two stand out. The court asserted that there was no risk of corruption or even appearance of corruption because all this new corporate spending would be independent from campaigns. Well, we know that's a joke. Worse, the court claimed that all this new political spending would be transparent. Billions of dollars in dark money spent since are galling proof that that was false. These false facts were not idle. They were essential to reaching the decision. To keep Congress away from regulating this massive new spending, the majority had to pretend the unlimited spending would not be corrupting. And independence and transparency were the two false predicates that got them across that bar. If the Citizens United majority didn't know those facts were false back then, they knew it soon, in the Bullock case, when Senator McCain and I wrote a brief pointing out that both their independence and transparency predicates were plainly false. But they didn't care. Indeed, didn't even allow argument. The false facts had gotten them to the result they wanted and were not to be disturbed. As evidence daily mounts of more and more corrupting dark money pouring into our elections, the Supreme Court has stubbornly refused to re-examine the false facts on which it propped its Citizens United result, despite ample opportunity to do so. I would add that there's an unpleasant correlation between the dark money that the decision unleashed and the dark money forces that got so many Federalist Society justices onto the court. Much of it fossil fuel money and influence. Indeed, if you want a specific example of post-Citizens United corruption, look at how fossil fuel dark money has stopped Congress from passing any serious bipartisan climate legislation. I was here in the Senate in 2007, 2008, and 2009, before Citizens United, when the Senate was working on 3 or 4 strong bipartisan climate bills. John McCain ran for president in 2008 with a serious climate platform. Then, in January 2010, came Citizens United, and that work all died instantly. No Republican has joined a serious climate bill since Citizens United, as the fossil fuel industry became the party's go-to funder, using an archipelago of front groups and identity laundering outfits purpose-built for that. We are in the jaws of a climate crisis caused by fossil fuel dark money, and Citizens United unleashed that peril. The one accurate finding of Citizens United was that unlimited spending would be corrupting if it were not transparent. Now, however, the right-wing justices are embarked on a mission to make dark money a constitutional right. Look no further than the Bonta decision, protecting the identities of the secret funders, of the corporate sibling, of the main battleship in the Koch brothers' political influence armada, Americans for Prosperity. In CAP's new report, Tom Moore and Alex Thornton propose a novel way to analyze and attack Citizens United. Their argument centers on how the ruling applies to for-profit corporations, as Citizens United itself involved a not-for-profit corporation. As Tom and Alex note, there are fundamental differences between the ownership and governance structures of for-profit and not-for-profit corporations. Those differences affect whether Citizens United's core assumption that the corporate entity in that case was an association of citizens should even apply to for-profit corporations. As Tom and Alex point out, if the rationale in Citizens United is that a corporation's right to participate in elections flows from the collected rights of its individual shareholders, it follows that the limits on those rights must also bind the corporation. Our largest for-profit corporations have many shareholders who are not U.S. citizens, who would be barred from spending in U.S. elections. So when for-profit corporations with foreign shareholders spend corporate funds in U.S. elections, they are de facto extending constitutional rights belonging to individual U.S. citizens over to foreign nationals. A related concern is that for-profit corporations operate under shareholder control. So it is anomalous to allow corporate officers to engage in dark money corporate political spending, even potentially self-dealing political spending, that shareholders aren't even told about. Whether it's selective principles, tortured analysis, false facts, foreign shareholder influence, or improper secrecy from shareholders, there are plenty of flaws in the Citizens United decision. But its fundamental indecencies are that it denies citizens basic information about who's doing what to whom on the political playing field that citizens ultimately oversee. And, oh yeah, its dark money is corrupting by its own terms. Thank you again to CAP for keeping the focus on this deeply flawed and corrosive decision, the product of right-wing billionaire influence, I would add. And to Tom and Alex for your good work in pursuit of restoring a fair and transparent American democracy.
Good afternoon. Thank you for coming today. My name is Tom Moore. I'm a senior fellow on the democracy team here at the Center for American Progress. Ben, Senator Whitehouse, thank you for getting us started. Now, even though Citizens United was a case about a nonprofit corporation, its holding was immediately ported over to for-profit corporations. The Supreme Court gave Citizens United, the nonprofit corporation, and all other corporations, the authority to spend in candidate elections. But because of the way the court went about it, it did not give for-profit corporate boards this right to spend that money. There are a lot of differences between nonprofits and for-profits, and they matter. For-profit corporate boards get their authority from shareholders voting their shares. But the Supreme Court based a corporation's ability to spend in candidate elections on another source entirely, the U.S. citizenship of the people who gathered together to make up the corporation. When for-profit corporate boards and their managers started spending in politics, they essentially started to steal constitutional rights and money from individual shareholders and handed them over to large shareholders and foreign nationals. That's a problem. We're here today to discuss this problem, as outlined in a new Center for American Progress report written by my colleague Alex Thornton and me. This report shows how this misapplication of Citizens United has injured shareholders, how those injuries could cost corporations in court, and how those lawsuits could throw sand in the gears of corporate political spending. We have a terrific panel today to discuss all of this. Commissioner Shana Broussard has served on the Federal Election Commission since 2020 and served as chair in 2021. She joined the commission in 2008 as an attorney in the Enforcement Division of the Office of General Counsel and served several years as counsel to a commissioner before being elevated to the commission herself. Commissioner Broussard's efforts to enable more people to run for federal office paid major dividends this past December as she led the successful effort to overhaul the commission's regulations regarding candidate salaries. Commissioner Broussard, welcome. Professor Sarah Haan holds an endowed chair at the Washington and Lee University School of Law and is currently a visiting professor at the University of Virginia School of Law. She writes at the intersection of corporate law and democracy, which is the exact intersection we are driving through today. Professor Hahn's article for the Stanford Law Review entitled Corporate Governance and the Feminization of Capital was chosen by her peers as one of the top 10 corporate and securities law review articles of 2022. She's contributed a chapter called The Corporation and the Labor Union in Election Law to the forthcoming Oxford Handbook of American Election Law. Professor Haan, welcome. Representative Jamie Raskin barely needs an introduction, but here goes. He is serving his fourth term as the congressman from Maryland's 8th Congressional District. Before that, he served 3 terms as a Maryland state senator and for 25 years as a constitutional law professor at the American University's Washington College of Law. Representative Raskin is the ranking member on the House Oversight Committee. He may be best known nationally for serving as lead impeachment manager in his effort to impeach Donald Trump for his role in the January 6th attack on the U.S. Capitol. But Representative Raskin is best known among members of CAP's democracy team and throughout the democracy community for his relentless efforts across multiple Congresses to get corporation money and foreign national money out of America's politics. He is the author of the Get Foreign Money Out of U.S. Elections Act and the Shareholders United Act. We found out yesterday that Representative Raskin has to leave us at 1:30 and go vote, so we'll try to front load his participation. Representative Raskin, welcome. And let's get right to the questions. The experience of this panel is overwhelming and overlapping, so please feel free to chime in on each other's answers. Congressman Raskin, you've examined the issue of corporate personhood for a long time. Corporations are not exactly people, my friend, but they kind of are. How do you think about this issue?
Well, thank you, Tom, and thank you to my friends at Center for American Progress and my fellow panelists. Hello, all you natural persons out there. I'm delighted to be here with the Citizens United Against Citizens United and all of its terrible implications for our democracy. I mean, the way I think of it is this: the Supreme Court, in a stunningly shallow and superficial opinion, basically transformed every corporate treasury in America into a political slush fund, which immediately the CEOs and the boards just started spending, freely with abandon because this seemed to be such a pro-corporate statist opinion. Then there are those of us, and you certainly are one of them, Tom Moore, who still believe in some principles of the rule of law and think that you actually have to analyze what's being said. And from the beginning, I said, well, wait a second, if a corporation is just an association of citizens, it's just a corporate association of citizens, then the corporate management or the board should not be able to authorize or direct the expenditure of money in political campaigns unless the shareholders whose money it is and whose First Amendment rights are putatively being vindicated have a say in it. It's like a membership organization where the membership's got nothing to do with what the organization actually does, right? And so as a state senator, and Tom, I think this is maybe where you and I first got together on this issue, but I repeatedly introduced legislation to say either, I think I started by saying there's got to be unanimous vote of the shareholders to spend the money. And, that's a kind of pure theoretical translation saying, well, if it's all of our money, all of us have to have a say in it. Then I retreated to the position of, okay, you need at least a majority vote of the shareholders. If the principle is one shareholder, one vote within this fictive corporate association of citizens, then at least by majority vote, we should decide that the money should be spent. And it could either be approving a general political budget that is then put in the hands of the corporate executives, which is pretty much what they do in the UK, or I preferred each particular political expenditure or contribution to a candidate must be authorized by majority vote of the shareholders. We were never able to get it through. We came, I think it was in committee votes of something like 5-4. I mean, we were coming very close, but the Chamber of Commerce in Maryland opposed us. every time on it. I still think that that is an authentic and perhaps the only really correct interpretation of Citizens United if you want to try to, make it coherent in the real world. And let me just also say that the implications of this excellent report you guys have done are several. One is that there may be derivative shareholder suits that are indicated for waste or misuse of corporate treasury money or actions ultra vires to the purpose of the corporation. We could act legislatively to pass something at the federal level, certainly with respect to corporate expenditure of corporate funds on political purposes that require a majority vote of the shareholders, or at least some elucidation of what the principle is to make sure that the members of the alleged corporate association have some say in what happens with the money. I think that there are potentially campaign finance actions, at least in some states, that would lie on this. For example, if there's a $5,000 limit on giving in a particular state, and I've maxed out to your campaign for governor, Tom, but then I'm a member of a 4-person corporation that gives to you too, I've just gone over the limit. Because, if they give you $20,000, I've given you double what I'm allowed to. There's another $5,000 attributable to me. So there's analysis that we can do about how the corporate Citizens United loophole is allowing some people to spend or give extra. Now, on the campaign independent expenditure side, of course, since the Supreme Court in Buckley defined that as a form of speech, you wouldn't necessarily be able to do it unless it was coordinated and thus attributable. But you certainly could do it where corporations are giving money directly to candidates. I know that's still in, a couple dozen, if not several dozen states where that's still going on. And then finally, I'll just put in a pitch for my Get Foreign Money Out Act. Of course, the Supreme Court, I think it was in the Blumen decision, upheld the ban on foreign nationals putting money into our elections. Leave aside the coherence and the reconcilability of that decision with everything else it says in Citizens United and Buckley. But in any event, it upheld the ban on outside money, but then created, as President Obama observed right after Citizens United, this huge loophole, which is if you have a US registered corporation, but it can take all of this money from foreign investors, foreign shareholders, or it can have foreign management. This is a way to drive a truck through a Supreme Court loophole to allow for foreign money to enter into our political system. So the Get Foreign Money Out Act is the federal version of something that I know different campaign finance reform groups have been working on around the country at the state and local level. And what we're trying to do is to close that foreign money loophole. And there's a lot of popularity to it. But of course, I think that they see that it could be the exception that swallows the rule, since there's so much foreign corporate investment or foreign shareholder investment in domestic corporations. And I yield back to you, Tom.
Thank you, Congressman. Commissioner Broussard, could we take a step back and could you give us kind of a quick primer on Citizens United? What happened in that case and what's been its effect?
Good afternoon, Tom. I'm happy to be here and happy to give that little history lesson to add to it. So Citizens United began in 2007 when a nonprofit corporation, and I stress the nonprofit part of it, filed a complaint challenging the constitutionality of certain statutory provisions requiring disclaimers and disclosure on communications. What was unique is that Citizens United had produced a film, the infamous Hillary the movie, about then Senator Hillary Clinton, and it wanted to broadcast it. Well, it was going to air it on video on demand, but it wanted to broadcast TV ads promoting it, and it was going to broadcast it in a window that was going to satisfy the definition of electioneering communications. What they did is they took advantage of a very unique provision in FECA that allows you to challenge directly in federal court. And so they went straight to court, eventually amended their petition to challenge the prohibition on disbursements for electioneering communications by corporations. What's no longer a surprise, because we've been dealing with this now for 14 years, is that the Supreme Court declined to rule on the very specific issue that was brought before them, and whether the ban was unconstitutional as applied to Citizens United. And instead, it did an entire challenge that it was facially unconstitutional. And thus, the saving grace, as some would call it, saving grace, is that the court upheld the disclaimer and disclosure requirements that had been the basis for it.
Is it fair to say that the court went further than it had to, given the facts and the complaint in the case?
Oh, I think personally, I think it's more than fair to say that it went beyond, because I mentioned it was an as applied challenge where they were simply trying to get some rulings regarding the disclaimers, to say what type of disclaimers, or just tell me I don't have to do it, disclaimers at all. And actually the court took that opportunity to do an expansion that I think it's fair to say that Citizens United didn't see at the time. But maybe that writing on the wall became a little more apparent when there was a re-argument of this matter.
All right, thank you. Professor Haan, as has been mentioned, the plaintiff in Citizens United was a Virginia chartered nonprofit corporation. The Supreme Court termed them an association of citizens. But there are real ownership differences between nonprofit and for-profit corporations. What are they, and how do they affect how a for-profit could be considered an association of citizens?
Tom, thank you so much for inviting me to be part of this wonderful event. The key difference here is that shareholders in a for-profit corporation have invested their money and they hope to get a return on their investment. So they have a financial interest in the corporation. The financial interest is denominated in the form of stock shares, which give the shareholder a pro rata claim on the corporation's surplus, essentially its profits. And so if the corporation goes under as well, the shareholders are residual claimants, which means that they can divide up what remains after all of the creditors are paid out, and they divide it up on a pro rata basis based on the shares. So stock shares also are important in one other way in a for-profit corporation, right? They give shareholders voting rights to elect the board of directors and, of course, to vote on other matters. And so the more stock you own, generally, the more votes you can exercise. In other words, corporate governance is organized on a plutocratic model. Nonprofit corporations, they work really differently. So they have no owners, right? Nobody with a financial claim on the nonprofit, no stock shares, and votes are not allocated on a plutocratic model. If members have voting rights, generally those voting rights are allocated on the basis of one person, one vote, which is the democratic model that's familiar to all of us from political democracy. The bottom line here is that members in a nonprofit corporation are basically equals, right, in determining the nonprofit's political voice. These are people who've really joined together in association to advance a particular social or political cause that they all agree on. They all share that commitment, and the voting structure is democratic. So when the framers gave Americans the constitutional right to association, this nonprofit model of association, the democratic model, is likely the model of association that the framers had in mind.
All right, thank you. Commissioner, CAP's new report focuses on the Supreme Court's description of corporations as associations of citizens who keep the rights they have individually when they're gathered together in corporate form. Who are the quote unquote citizens who have the right to spend in U.S. elections? Is it everyone?
I think I'm going to speak and answer that question from a Federal Election Campaign Act standpoint. And so under FECA, there is an important thing that we all have heard about, and a couple of our speakers today have mentioned foreign nationals. And I want to highlight that. And I actually want to read you the definition of a foreign national, because I think it's really important for your audience. And that a foreign national is defined as an individual who is not a U.S. citizen or national or a lawfully admitted permanent resident, a government of a foreign country or a foreign political party or a partnership association, corporation, organization, or other combination of persons organized under the laws or having its principal place of business in a foreign country. All of these entities, individuals, organizations are not allowed to participate, are prohibited from spending in US elections. So when we talk about that association, I think you got to make sure that you keep this in that definition of what we're looking at. And the answer is foreign nationals are prohibited from spending.
Okay, thank you. And it's funny, I'm guilty of this too, using kind of citizens as shorthand. Folks with folks with green cards, they are also able to give in US elections. Is that right?
Yes, that individual is going to fit into that definition of a lawfully admitted person. You're fitting into, you're okay when you get to that one.
Okay, thank you. Professor Haan, as you mentioned before, generally speaking, corporate power is wielded by those who own the most shares. And as we're discussing today, that's a problem when it comes to exercising political rights, where everybody is bringing equal rights to the table. Has it always been the case when it comes to even the general corporate power that it was one share, one vote, or what's been the progression there?
Yeah, it hasn't always been the case at all. In the 19th century and right after the founding, corporate law did not exclusively rely on one share, one vote. And in fact, in the first half of the 19th century, corporations used a number of different systems, approaches, which we today, scholars call it restricted voting. So restricted voting in the 19th century restricted the votes of wealthy block holders. Essentially, the more shares you held, the fewer votes attached per share. This is graduated voting. And so the purpose of graduated voting was to limit the voting power of wealthy investors in order to even the playing field for small shareholders within corporate organization. And even on top of graduated voting, some corporations employed voting caps, which capped the total number of or percentage of votes that any one wealthy actor could exercise. So this was another way to limit the voting power of wealthy block holders inside the corporation. And we even know that some corporations were using both of them at the same time. I mean, they were really serious about restricting the voting power of wealthy actors. So, for example, the First Bank of North America, the First Bank of the United States, which used 7 tiers of voting strength, smaller votes attached, the more shares you held, and at the same time, also a voting cap. So this is not, what we don't see is a perfectly democratic vote allocation, one person, one vote, but it was much more democratic than you see in modern corporations.
Okay, and that what you're describing is absolutely alien to what we see in corporations now, where it's just a given that whoever has the most shares within a class of stock is has the most power. What ended that? When did it end, and what caused that to end?
Well, scholars debate this. I mean, I'm one of the scholars who's written on this subject. The move to one share, one vote happened over the course of the 19th century. Basically, after the Civil War, you see a lot of states, because corporate law is state law, so every state is sort of developing its state law on a different timeline, but you see all the states essentially moving to one share, one vote. I mean, there are scholars that put forward various reasons, and honestly, there's no agreement among scholars. I wish I had a better answer.
No, your answer is good enough. Thank you. Yeah, we'll take yours. Commissioner, as Senator Whitehouse pointed out, the Citizens United decision rested on 2 key assumptions. First, that as a matter of law, there is no risk of corruption or appearance of corruption from unlimited corporate spending, because it would be all independent from campaigns. And second, that all this new spending would be transparent. Now, from your seat on the Federal Election Commission and based on your years of experience as a commission attorney before your service, how's that worked out? Is that what you see?
Well, Tom, in my experience, in my opinion, the court's assumption regarding effective disclosure has not come to fruition. A significant amount of election-related spending is taking place in secret, and you're going to especially find this, or really not find this, on the internet. Massive amounts of money are flowing from wealthy donors and corporations to super PACs and other corporate entities masquerading as nonprofit social welfare groups, but they're really political committees under the definition of FICA. The commission is frequently confronted with issues involving whether and to what extent corporate and union spending to influence elections should be disclosed, including whether a 501c4 group's political spending rises to the level such that they should be deemed a political committee under FICA. And as you know, and as everyone can imagine, commissioners have different views about what the FEC can and should do on these issues. But the fact that the 501c4 organizations don't have to disclose their donors, and combined with the fact that they can make contributions to super PACs, makes it very difficult to assess the size of the problem. And was mentioned by Open Secrets. One of us mentioned Open Secrets had reported that political committee contributions from dark money groups, including C4s, to super PACs skyrocketed. And it skyrocketed almost 500% in 2022. From 2010 to 22 when the decision came out. But we don't know how much of that is originating from for-profit corporations, and that's part of the problem.
Okay, thank you. Professor Haan, in the report, we kept it simple and talked about shareholders voting a single class of shares. In the real world, it's more complicated. Lots of classes and lots of voting rights, that kind of thing. Do these complications make the problem we identified in our report better or worse?
In my view, significantly worse. Basically, over the past 20 years, since about 2004, many American corporations have moved toward dual class or multiple class voting structures, which allow corporations to create different classes of stock that have different vote allocations attached to the classes. And this is actually, this is the opposite of the 19th century model that I was just describing. Instead of limiting the voting power of wealthy block holders, modern dual class structures actually give extra votes to wealthy block holders who often happen to be the founders or their affiliates or family members of the founders of companies. And so as a result, these this small number, this small group ends up dominating corporate decision-making. We see this especially today, you know, in the 21st century, we see this especially at large publicly traded tech companies where dual class structures have, honestly, they have proliferated. Meta, for example, Facebook, people are familiar with. Mark Zuckerberg holds about a 13% interest in the company's finances, but he exercises more than 61% of its voting power, one person. The same is true at Alphabet, you know, which people are familiar with as Google. There are two founders who own less collectively than less than 12% of the financial interest of the company, but exercise more than 50% of the voting power. And I could go on and on. Lots of companies, Snapchat, Airbnb, Ford Motor Company, a lot of name brand companies have these dual class structures. And as a consequence of the structures, corporate decisions, including corporate political decisions, right, or political spending decisions, they're being driven by the interests and the desires of a tiny subset of shareholders.
So it's not even as that system has progressed, it's not even the shareholders themselves are not being their views not being heard on an equal basis.
I mean, you're essentially disenfranchised, right? If you're a common shareholder at a company with a dual class stock structure.
Thank you. All right, so this question is for the both of you. What is the result of all this? As Ben mentioned, Anthony Kennedy and Citizens United wrote that the appearance of influence or access will not cause the electorate to lose faith in this democracy. That was a prediction. 14 years of experience since that prediction. What does your experience tell you about that?
Well, I will go, Tom, before the professor, if she doesn't mind. In a tangible sense, I think it's increased to, there's been a massive increase in campaign spending. It's led to the creation of the super PAC. That is now just a part of our everyday vernacular, at least in the world of the three people that you see on the screen. But you can look at how we have had increases in the 300% from what is being spent in election years. But there is a study that Ben mentioned at the introduction that I think is worthy of anybody who has an interest in this, taking a look at this 2023 Pew study that found that 73% of US adults say that lobbyists and special interest groups have too much influence on members of Congress. And furthermore, 85% of Americans say that the cost of political campaigns makes it hard for good people to run for office. Essentially what is happening is that this decision and the resulting actions of it have led to such a decrease in the faith in the electoral process, which in another factor, not what we're talking about today, I think leads to a lack of participation, which is the last thing that you want as you lead into an election year.
I really agree with what the commissioner just said. I really think that as a prediction, it was just flat wrong. And I think it's really unfortunate that that prediction gets embedded in the Citizens United opinion almost as a statement of law, like independent expenditures are not corrupting as a matter of law. Why? Because the justices say so. When I think all the rest of us participating and watching in American democracy don't feel that's the case, and we are observing different things.
Okay, thank you. We have some audience questions now. We have Mark Hulbert of MarketWatch has asked, and this is I know neither one of you are securities class action lawyers, but he has asked, what is the likelihood of a court siding with Cap's argument, and what's the probability of reform legislation making it through Congress?
So I think there are still some issues to work out with this theory. I mean, I'm optimistic about this theory. I think there's a lot of merit to this idea that when the corporation is exercising First Amendment rights, what it's really doing is it's acting as an association of the shareholders who animate the corporation. And therefore, what it's really doing is it's sort of exercising the rights on a kind of pass-through, almost a pass-through basis, the rights of the shareholders. And of course, not all the shareholders are going to have American political spending rights, because not all of the shareholders are American citizens or are qualified under the law. I think there's a lot of merit to this idea. I do think that there may be some hurdles, some legal hurdles with framing it properly as litigation, which I think is what this question is designed to get at. So it's sort of a work in progress is my understanding.
Commissioner, you want to take a shot at that?
Yeah, I'm going to take a shot, but I'm going to try to take my shot as it relates to campaign finance and FICA, because the question kind of comes down to not only how the corporations make the decisions on whether and how to spend the money on independent expenditures, because I think that's where the problem comes down. But it's a part of question of campaign finance law, for example, going with the foreign national part that make decisions on about how funds are being used. But it obviously goes into corporate governance. And so from the issue of trying to expand upon this in FICA's world, I think the foreign national kind of like, let me just say, kick of it is the way to go. And there have been previous proposed legislation. I'm probably thinking of an old version of the Disclose Act, but there have been instances where Congress or our legislatures have challenged the cause where we want to know how much of a board or a corporation has that foreign national contingency and how much is available for the public to know about that. I think that exposure helps to promote the cause even more. So if I were going to say, hey, what CAP is trying to do, if you're going to push it for the corporate governance, I think there is a very window through the foreign national angle that there is something that becomes viable for this. Okay,
thank you. We have a question from one viewer, kind of a more structural question to take a couple steps back on this. Is there a distinction between corporate PAC contributions to campaigns versus super PAC contributions to campaigns? Or do super PACs make contributions to campaigns?
No. Well, let me say, I'm sorry, excuse me for jumping over the professor if you wanted to go, is that I think one of the things we have to think about, super PACs cannot make direct contributions to campaigns. But what everybody was mentioning is what's been happening in the world of FICA. I feel very animated about this because I think this is this is where all, let's just say, campaign finance nerds unite. Independent expenditures, are they actually independent? Is the question that we're coming down to, is because what we've seen even more in this world is that we've had the issue of coordinated expenditures that come into play. Big money, according to the Supreme Court, an independent expenditure is independent, so it's not corrupting. But I think what's happened is the proliferation of money into this context has led to more coordination. And from the aspect of my agency, that becomes a challenge to be able to prove, because there are very finite set rules that you have to establish. And not to take it too deep, I've got to prove that there's a third party paid for it. I've got to prove that it fits a content prong, that it's a public communication. Usually those things are pretty easy, but it's the final thing that becomes hard to prove, the conduct. And I have to be able to dig into the secret mind of everyone, whether there's been a request or suggestion or things like that. And thus, without some building upon the statutes in FICA to adjust where the new world is for independent expenditures and modify what the definitions are for coordinated communications, I'm not going to be able to cross that bridge.
Yeah, thank you. Professor?
Yeah, just really quickly, corporate PACs and super PACs are really different. And, it is frustrating, I think, for experts to that there's so much complexity here. And I think it's really actually challenging for people who are not lawyers and are not experts in campaign finance to even understand what's going on. A corporate PAC gets its money. It can donate directly to candidates. And they do, lots of big publicly traded companies have corporate PACs, and the corporate PACs donate directly to candidates for public office, but it's not the corporation's money. The corporation is actually going out and gathering money that comes from the bank accounts of the shareholders and the employees, often typically the officers and directors of the corporation. They give their money voluntarily to the corporate PAC, and then the corporate PAC moves that money on to candidates for public office who support things that the corporation is enthusiastic about. And then that, those expenditures can be counted against you as far as your contribution limits. Super PACs are completely different. Super PACs didn't even exist before Citizens United, right? So one of the main criticisms of Citizens United is that it unleashed the sort of super PAC phenomenon. Super PACs are supposed to be, as the commissioner was explaining, independent expenditure only. Corporations give a lot of corporate treasury money. That is just the corporation's money to super PACs. And that money is supposed to be disclosed. The super PAC discloses where it gets its money, and that money is put to independent expenditures. So anyway, even though I feel like I just explained that, I understand that there's so much complexity there. You have to take a class in campaign finance to unpack it all. It's such a shame.
No, thank you for that, though. So basically, I think the distinction I've always thought is PAC contributions and regular contributions are limited because they do have the appearance of, they could create corruption or the appearance of corruption. But anything that's independent, as a matter of law, according to the Supreme Court, cannot possibly be corrupting. And that is, there's obviously problems with that, but that is the law as we're working with it. Is that right?
Yeah, that's completely right. I'm so glad you added that on, because I think that is actually really important to be specific about that. The way that Supreme Court thinks about money in politics, if you're giving money directly to a candidate, that can be limited in some ways. And so we do have caps on that kind of spending. But independent expenditures are supposed to be not corrupting, right? That's what Citizens United said, and what I was critical about a few minutes ago. And so as a consequence, according to the Supreme Court, under the First Amendment, the government cannot limit independent expenditures, cannot limit corporate independent expenditures. Unlimited independent expenditures are allowed after Citizens United.
One of the things that when I was first looking at these issues, one of the things that blew my mind looking at the whole coordination question was that there's this thing called functional coordination, where maybe a campaign and a super PAC no words ever cross between the two, but the super PAC knows that the super PAC's job is to do the negative advertising and the campaign's job is to do the positive advertising. So they can run every campaign and every super PAC can run a fully coordinated campaign that way, where the campaign's got full deniability on all the negative stuff, but they've never spoken a word, and they have never done anything that would come even close to violating the commission's coordination regulations. And once I saw that, it was like, oh, there's just no way to police this, because they don't even have to communicate in order to coordinate.
Well, I guess my answer is going to be bingo. That has been the campaigns and super PACs have become more and more sophisticated in how they are doing this. And I think sophisticated is actually not the right word. They've become more simple in how they're doing this. But it results in a sophisticated answer for the commission to be able to address. Because as I mentioned before, when you're talking about the coordinated communication regulations, there's safe harbors inside of this. And these safe harbors have not been adapted or modified post-CU. And so things become publicly available. And we've had MERS in cases that are closed where you've had videos of just footage of candidates that are just shaking hands with the local farmer or taking in the parade, and all of this kind of really great feed that you're going to then find just dropped into an ad. And it miraculously appeared just, 2 weeks before an ad was then swooped up by a super PAC to be able to do it. So there is this proliferation that the campaign finance law has not caught up to Citizens United, because this is where you get to the kind of the background of this agency is comprised of 6 individuals, 3 on this side, 3 on that side, and we've got to come together to be able to do it. It's not that it hasn't been proposed. There's a commissioner, the vice chair has made several times over some efforts to just kind of intercede and try to move this along, but we've got to be able to have consensus to be able to do it. And thus, most of this that's occurring is happening through the enforcement context, where it becomes difficult to move this because we don't have active regulations that are post-CU.
Right. We have an audience question about other methods of blunting CU's effects or getting past it. Is there, in your opinion, is there any hope for a constitutional amendment to overturn Citizens United?
No. I say this to everybody. Don't ask me to be here if you don't want me to speak my truth. And my answer is no. As the court has moved more to a conservative leaning, the likelihood of this being overturned, and I think a reasonable time period is I want to just be honest, like by a court effort, I don't see that happening. I think if you read some of the history that how we actually got to the Citizens United decision and how the court, and as your paper says this, it does a great job of outlining the political campaign finance history, starting from Buckley all the way down, is that the court has incrementally, I'm going to just do it like this, carved away some of the restrictions, and restrictions is not word, is some of the deterrents that they were attempting that previously set out by Buckley is bit by bit. And the real effort was done by the court is when Austin came out, the Austin decision. I think this group was like, oh no, we got to do something about this. And so then slowly you got some additional decisions before you had the opportunity in CU. And so I don't see it happening court-wise, but I do feel that when you look at the public opinion on how they feel about this is why I think the greatest effort could come through the legislative efforts. And that's where I think that there should be some of the push, at least as it relates to getting something on the books that I personally would say through foreign national involvement, through those means to try to codify the corrupting influences that actually can come from independent expenditures.
You know,
Professor?
a constitutional amendment would solve this problem because it would overrule, essentially, it would be sort of a democratic way of overruling the bad Citizens United decision. But we really haven't seen the political will to get a constitutional amendment going. A few years ago, Justice Stevens wrote a book called 6 Amendments, in which he proposed an amendment that would overwrite Citizens United or sort of fix the Citizens United problem. And it was very simple, simply worded amendment. Then it, of course, you know, if your amendment is too simply worded, then I think the commissioner's point is very sharp, right? That you've still got a conservative Supreme Court that's going to now interpret a brand new amendment and interpret it in, you know, using the same tools that they've been using all along. But it is frustrating that we don't really see a political movement to pass through a new amendment, which I do think it's the ultimate fix.
Okay, thank you. We have identified lawsuits as one way that the issues that we've identified could be addressed. Is there another way that institutional individual investors could effectuate these corporate procedures so that citizen, non-citizen, multiple shareholders, that kind of thing, that could be balanced out? Or is there anything internally that can be done? Or is it is lawsuits the best route?
So the lawsuit route is one possible route, but I do think that, so in corporate law, you know, we talk a lot about private ordering, which is when the corporations sort of make rules for themselves, and it doesn't come from outside the corporation, but sort of internally, where you have the will of the shareholders to change something about the way that the governance of the organization is working. And so it certainly could be the case that corporations could make decisions for themselves about how to allocate votes. I mean, for example, there is some historical basis for vote allocations working differently based on subject matter. So, you know what, you do see some statutes, some state law statutes back in the 19th century that singled out a particular topic that was getting voted on inside a corporation and said, here's how the vote allocations are going to work for this particular topic. And so a corporation could adopt that approach through its bylaws for itself as a matter of private ordering. Or honestly, I mean, a state legislature could impose that new rule for all of the state's corporations by passing legislation. The only problem with that, and I don't want to get too deep into it, but when you're relying on states to change state corporate law, that is a bit dicey because the states are essentially in competition with each other to produce state corporate law that meets the needs and the interests of the people who sometimes we say buy state corporate law, in other words, corporate managers. And so you're seeing this play out, for example, when Elon Musk says, oh, I want to leave Delaware. I want Tesla to leave Delaware and go to Texas, right? What is he doing? He's sort of activating this competition between the states. And I think you would see that if one state started pioneering different rules, the danger is that other states would say, oh, we're not doing that, you know, come here. And so you get this sort of race to the bottom, which is familiar to corporate law experts. But I mean, there are other mechanisms. You're exactly right to ask this question. There are other ways to address what I think is this misallocation of voting power behind the corporate voice, where you have foreign shareholders' interests suddenly making their way into the American political system.
Okay, thank you. We are out of time. Is there any final short words you'd like to tell the audience?
Oh my God. I mean, I would say thank you so much to the Center for American Progress for teeing this issue up, for really exploring it deeply. It's complicated. It's not easy, but it's so important to have these conversations.
I want to tag on to the comments of the professor. Thank you to CAP for inviting all of us today. It's a unique way to get an issue that so many Americans care about in front of the public, and I look forward to the work that you continue to do.
Thank you. So on behalf of the Center for American Progress, thank you to Commissioner Shana Broussard, Professor Sarah Haan, Congressman Jamie Raskin, and Senator Sheldon Whitehouse. And thank you to everyone who attended today. Our report and lots of other great information is available at americanprogress.org. Thank you.